Let us continue our topic on Katarungang Pambarangay. So we have here conciliation. So what is conciliation? Conciliation is used to overcome the distrust or animosity or hatred of a piece or to pacify. It is also to regain or try to regain friendship or goodwill by pleasant behavior. And lastly, to make or attempt to make compatible or to reconcile. Mediation is a form of alternative dispute resolution aims to assist two or more disputants in reaching an agreement. And arbitration is a legal technique for the resolution of disputes outside the courts wherein the parties to the dispute refer to it to one or more persons or the arbiters or the arbitral tribunal by whose decision or this what we call award they agree to be bound. Repudiation means the refusal to acknowledge a contract or a debt. The essence of the Katarungang Pambarangay Law is the amicable settlement of disputes wherein the disputing parties are encouraged to make mutual concessions to obtain a peaceful resolution of the dispute without formal adjudication. So the important consideration in amicable settlement is the extent to which the parties are willing to compromise their respective claims against each other within the limits imposed by law, morals, good customs, public order, and public policy. Take note that the barangay settlement procedures are intended as a screening process whereby the barangay captain and the pangkat ng Tagapagkasundo, the conciliation panel, constituted from the Lupon membership, determine which cases are truly irreconcilable and should therefore be resolved judicially. For the mediation by the Lupon chairman, upon receipt of the complaint, the Lupon chairman shall within the next working day summon the respondent or the respondents with notice to the complaint or complainants for the team and their witnesses to appear before him for a mediation effort within 15 days from the first meeting of the parties before him. So he shall forthwith set a date for the constitution of the Pangkat in accordance with the provisions of this particular chapter. For the suspension of the prescriptive period of offenses, while the dispute is under mediation, conciliation, or arbitration, the prescriptive period for offenses and cause of action under existing laws shall be interrupted upon filing the complaint with the punong barangay. So the prescriptive periods shall resume upon receipt by the complainant of the complaint or the certificate of repudiation or of the certification to file action issued by the Lupon or Pangkat Secretary. Provided, however, that such interruption shall not exceed 60 days from the filing of the complaint with the punong barangay. For the issuance of summons, hearing grounds for disqualification, the Pangkat shall convene not later than 3 days from its constitution on the day and the hour set by the Lupon chairman to hear both parties and their witnesses and to simplify issues and explore all possibilities for the amicable settlement. For this purpose, the Pangkat may issue a summons for the personal appearance of parties and witnesses before it. In the event that a party moves to disqualify any member of the Pangkat by reason of relationship, bias, interest, or any other similar grounds discovered after the constitution of the Pangkat, The matter shall be resolved by the affirmative vote of the majority of the Pangkat, whose decision shall be final. Should disqualification be decided upon, the resulting vacancy shall be filled as herein provided for. The period to arrive at a settlement, the Pangkat shall arrive at a settlement or resolution of the dispute within 15 days from the day it convenes in accordance with this section. So this period shall at the discretion of the Pangkat. It can be extendable for another period which shall not exceed 15 days except in clearly meritorious cases. The barangay system of dispute resolution is an institution established through the Presidential Decree number 1508 to shift or segregate cases that can be peaceably or amicably settled between the parties and those which are truly irreconcilable as to require formal adjudication before the courts or other government offices. The former type of cases are prevented from reaching the regular courts of justice or government offices performing adjudicatory functions, the dockets of which are thereby relieved of congestion of pending cases, meaning it lessen the cases that can be docketed in courts or in government offices. So through the barangay conciliation, okay, it can lessen the pending cases in courts or in any government offices. The Katarungang Pambarangay Law promotes the speedy administration of justice. Through this, okay, cases can be decided through the barangay level by the barangay captain and authorities who are involved in the conduct of amicable settlement. Peaceful and friendly settlement is one of the purposes of the barangay or Katarungang Pambarangay Law. So this is used to relieve trial courts of cases among neighbors that hopefully can be settled through the mediation of their peers in peaceful and friendly confrontation in the barangay level. By compelling the disputants to settle their differences through the intervention of the barangay leader and other respected members of the barangay, the animosity or the hatred which is generated by protracted court litigations between members of the same political unit, a disrupted factor toward unity and cooperation is avoided. Perpetuate tradition and culture. So the term barangay level distinguishes the system instituted by Presidential Decree number 1508. Uh, Now the uh, local government uh, code for the purpose of perpetuating and giving official recognition to our time-honored tradition of resolving disputes among family and barangay members from the court system, which performs the same function of resolving disputes or controversies, but through formal and technical rules of procedure. Interest of public peace and order. While it is conceded that the state has the sovereign right to prosecute criminal offenses and that the fiscal has full control in public prosecution through Presidential Decree number 1508 or the Local Government Code states the states the prosecuting arm of the government in cases of light offenses, and it allows the party to settle their differences in the larger and greater interest of public peace and order. Take note that the Barangay Council is the barangay's lawmaking body, created under the revised Barrio Charter or the RA 3590 as amended. The Lupong Tagapamayapa is the council created under Presidential Decree 1508. So the Lupon is a conciliation body separate and distinct from the Barangay Council or the Sangguniang. Under the provisions of Republic Act 7160, there is hereby created in each barangay a Lupong Tagapamayapa, hereinafter referred to as the Lupon, which composed of the barangay or the punong barangay as the chairman and the 10 to 20 members. So the Lupon shall be constituted every 3 years in the manner provided by the law. Any person actually residing or working in the barangay not otherwise expressly disqualified by the law and possessing integrity, impartiality, independence of mind, sense of fairness, and reputation for probity may be appointed as a member of the Lupon. A notice to constitute the Lupon shall include the names of proposed members who have expressed their willingness to serve, shall be prepared by the punong barangay within the first 15 days from the start of his term of office. Such notice shall be posted in 3 conspicuous places in the barangay continuously for a period of not less than 3 weeks. The punong barangay, taking into consideration any opposition to the proposed appointment or any recommendations for appointments as may have been made within the period of posting, shall within 10 days thereafter appoint as members those whom he determines to be suitable. Therefore, appointments shall be in writing, signed by the punong barangay, attested by the barangay secretary. Take note also that the list of appointed members shall be posted in 3 conspicuous places in the barangay for the entire duration of their term of office. And in barangays where the majority of the inhabitants are members of indigenous cultural communities, local systems of settling disputes through their councils of datus or elders shall be recognized without prejudice to the applicable provisions of this code. The function of the Lupon Tagapamayapa is primarily conciliatory. If we say conciliatory, they use negotiation approach, not adjudicative, meaning they don't have the right to make an official decision about who is right. So the Lupon shall exercise administrative supervision over the conciliation panels provided in this code. Meet regularly once a month to provide a forum for matters relevant to the amicable settlement of disputes and to enable various conciliation panel members to share with one another their observations and experiences in effecting speedy resolution of disputes, exercise such other powers, and perform such other duties and functions as may be prescribed by law or ordinances. The Lupon Tagapamayapa is an administrative body. It has only such powers and functions as are conferred on it expressly or by necessary implication by the law that created it. The punong barangay or the barangay captain is the ex officio chairman of the Lupon of his barangay by express provision of PD 1508. So upon him alone devolves the ipso facto or the powers and duties of the chairman of the Lupon. So namely to constitute the Lupon, to mediate and arbitrate disputes, to constitute the Pangkat ng Tagapagkasundo, and to perform miscellaneous duties relative to the regular monthly meetings of the Lupon. The most senior concealman succeeds to substitute for the punong barangay in case the latter ceases to hold office or is unable to perform his duties under the Katarungang Pambarangay Law. If said senior concealman likewise ceases to hold office or is unable to perform said duties, the process of succession successively devolves upon the other concealmen in order of their seniority. What is improper substitution? If we say improper substitution, there is no personal confrontation of the parties before him for mediation. So the punong barangay instead referred the case to a lawyer who acted thereon purportedly as a Pangkat chairman. So under these circumstances, the assumption by the said lawyer of the position of chairman of the Pangkat ng Tagapagkasundo was devoid of legal basis because of non-compliance with the statutory requirement of personal confrontation of the parties before the punong barangay as provided under Section 4 of Presidential Decree 1508 and with the procedure prescribed by the law for the selection of the Pangkat chairman. So take note, it is a requirement that there must be a personal confrontation of the parties before the chairman, okay, for the purpose of mediation. Moreover, it does not appear that said lawyer is a senior member of the barangay council who can substitute for the punong barangay as Lupon chairman. Take note that only members of the Sangguniang barangay in the order of their seniority can succeed to or substitute for the punong barangay as the Lupon chairman. The authority of every Lupon constituted for a particular barangay is coextensive with the territorial limits of the said barangay. Thus, the Lupon may not exercise its authority outside the territorial confines of its own barangay. The barangay secretary shall concurrently serve as the secretary of the Lupon. The barangay secretary shall record the results of the mediation proceedings before the punong barangay and shall submit a report thereon to the proper city or municipal courts. Uh, he shall also receive and keep the records of proceedings submitted to him by the various conciliation panels. There shall be constituted for such dispute brought before the Lupon a conciliation panel to be known as the Pangkat ng Tagapagkasundo. So hereafter referred to as the Pangkat, consisting of 3 members who shall be chosen by the parties to the dispute from the list of the members of the Lupon. Should the parties fail to agree on the Pangkat membership, the same shall be determined by uh, lots drawn by the Lupon chairman. So take note, if the parties will disagree on the chosen members of the Pangkat, so there will be a draw lots and it will be determined by the Lupon chairman. The 3 members constituting the Pangkat shall elect from among themselves the chairman and the secretary. The secretary shall prepare the minutes of the Pangkat proceedings and submit a copy duly attested by the chairman to the Lupon secretary and to the proper city or municipal court. He shall also issue and cause to be served notices to the parties concerned. So the Lupon secretary shall issue certified true copies of any public record in his custody that is not by law otherwise declared confidential. Any vacancy in the Pangkat shall be chosen by the parties to the dispute from among other Lupon members. Should the parties fail to agree on the common choice, the vacancy shall be filled by lot to be drawn by the Lupon chairman. Take note that the choice of the Pangkat members is the party's prerogative. So the rationale for this procedure is that the parties would be better disposed to amicably settle their dispute before a conciliation panel whose members are freely chosen by them. The members, while in the performance of their official duties or on the occasion thereof, shall be deemed as persons in authority. If we say persons in authority, we are referring to any person directly vested with jurisdiction, whether as an individual or as a member of some court or government corporation, board, or commission, including the barangay captains. The Lupon or Pangkat members shall serve without compensation except as provided in Section 393 and without prejudice to incentives as provided for a system of granting economic or other incentives to the Lupon or Pangkat members who adequately demonstrate the ability to judiciously and expeditiously resolve cases referred to them. Take note that while in the performance of their duties, the Lupon or Pangkat members, whether in public or private employment, shall be deemed to be on official time and shall not suffer from any uh, diminution in compensation or allowance from said employment by reason thereof. So if they will serve as Lupon or Pangkat, regardless if they are employed in public or private, okay, it cannot be a reason for them, or this could not be a reason to deduct their absences, okay, or this particular service that they will render will be on official time, meaning they will be excused in their work. The provincial, city, legal officer or prosecutor, or the municipal legal officer shall render legal advice on matters involving questions of law to the punong barangay or any lupon or pangkat member whenever necessary in the exercise of his functions in the administration of the Katarungang Pambarangay. The lupon of each barangay shall have authority to bring together the parties actually residing in the same city or municipality for amicable settlement of all disputes, except where one party is the government or any subdivision or instrumentality thereof, where one party is a public officer or employee, and the dispute relates to the performance of his official function. N. Offenses punishable by imprisonment exceeding 1 year or a fine of 5,000 pesos. Offense where there is no private offended party, where the dispute involves real properties located in different cities or municipalities, unless the parties thereto agreed to submit their differences to amicable settlement by an appropriate lupon. And disputes involving parties who actually reside in barangay of different cities or municipalities, except where such barangay units adjoin each other and the parties thereto agreed to submit their differences to amicable settlement by an appropriate lupon. Such other classes of disputes, which the President may determine in the non-proprio justice or upon the recommendation of the Secretary of Justice. So the court in which non-criminal cases not falling within the authority of the lupon under this code are filed and may any time before trial. Non-proprio refers to the case to the lupon concerned for amicable settlement. So let us talk about the venue of the conciliation. One, disputes between persons actually residing in the same barangay shall be brought for amicable settlement before the Lupon of the said barangay. Take note if they are residing in the same barangay. Those involving actual residents of different barangays within the same city or municipality shall be brought in the barangay where the respondent or any of the respondents actually resides at the election of the complainant. 3. All disputes involving real property or any interest therein shall be brought in the barangay where a real property or the larger portion thereof is situated. Those arising at the workplace where the contending parties are employed or at any institution where such parties are enrolled for study shall be brought in the barangay where such workplace or institution is located. Objections to venue shall be raised in the mediation proceedings before the punong barangay, otherwise, the same shall be deemed waived. So take note that any legal questions which may confront the barangay or the punong barangay in resolving objections to the venue herein referred to may be submitted to the Secretary of Justice or his duly designated representative whose ruling thereon shall be binding. Who may initiate proceedings for amicable settlement. Take note that any individual who has a cause of action against another individual involving any matter within the authority of the Lupon may complain orally or in writing. So, uh, this will be filed to the Lupon chairman of the barangay. So, the settlement shall be recorded in a manner that all amicable settlements must be in writing in a language or dialect known to the parties, signed by them, and attested by the Lupon chairman or the Pangkat chairman. As the case may be, okay, when the parties to the dispute do not use the same language or dialect, the settlement shall be written in the language or dialect known to them. Okay, next is the conciliation proceedings a precondition to the filing of complaint in court? So the answer is yes. Take note that no complaint, petition, or proceeding involving any matter within the authority of the Lupon shall be filed or instituted directly in court or any other government offices for adjudication, unless there has been a confrontation between the parties before the Lupon chairman or the Pangkat, and that no conciliation or settlement has been reached as certified by the Lupon secretary and as attested to by the Lupon chairman or Pangkat chairman, or unless the settlement has been repudiated by the parties thereto. However, the parties may go directly to court if where the accused is under detention, where a person has otherwise been deprived of personal liberty calling for habeas corpus. If we say habeas corpus, it means to bring a prisoner or other detainee before the court to determine if the person's imprisonment or detention is lawful. Third, where actions are coupled with the provisional remedies such as preliminary injunction, attachment, delivery of personal property, and support pedente light, or this what we call awaiting litigation. One of the example is the child support, where the actions may otherwise be barred by the statute of limitations. Conciliation among members of indigenous cultural communities. Okay, take note that the Customs and traditions of indigenous cultural communities shall be applied in settling disputes between members of the cultural communities. The parties may at any stage of the proceeding agree in writing that they shall abide by the arbitration award of the Lupon chairman or the Pangkat. So such agreement to arbitrate may be repudiated within 5 days from the date thereof for the same grounds and in accordance with the procedure hereinafter prescribed. The arbitration award shall be made after the lapse of the period for repudiation and within 10 days thereafter. Take note that the arbitration award shall be in writing in a language or dialect known to the parties. So when the parties to the dispute do not use the same language or dialect, the award shall be written in the language or dialect known to them. All proceedings for settlement shall be public and informal, provided, however, that the Lupon chairman or the Pangkat chairman, as the case may be, may motu proprio or upon request of a party exclude the public from the proceeding in the interest of privacy, decency, or public morals. Who should be present during conciliation? In all Katarungang Pambarangay proceedings, the parties must appear in person without the assistance of counsel or representative, except for minors and incompetents who may be assisted by their next of kin who are not lawyers. The amicable settlement and arbitration award shall have the force and effect of a final judgment of a court upon the expiration of 10 days from the date thereof, unless repudiation of the settlement has been made or a petition to nullify the award has been filed before the proper city or municipal court. However, this provision shall not apply to court cases settled by the Lupon under the last paragraph of Section 408 of this code, which was discussed a while ago, in which case the compromise settlement agreed upon by the parties before the Lupon chairman or the Pangkat chairman shall be submitted to the court and upon approval thereof have the force and effect of the judgment of the said court. The amicable settlement or arbitration award may be enforced by execution of the Lupon within 6 months from the date of the settlement. After the lapse of such time, the settlement may be enforced by action in the appropriate city or municipal court. Any party to the dispute may within 10 days from the date of the settlement repudiate the same by filing with the Lupon chairman a statement to that effect sworn to before him, where the consent is betrayed by fraud, violence, or intimidation. Such repudiation shall be sufficient basis for the issuance of the certification for filing a complaint as here in above provided. Take note that the Secretary of the Lupon shall transmit the settlement or the arbitration award to the appropriate city or municipal court within 5 days from the date of the award or from the lapse of the 10-day period repudiating the settlement and shall furnish copies thereof each of the parties to the settlement and the Lupon chairman. The punong barangay as the chairman of the Lupong Tagapamayapa and the members of the Pangkat are hereby authorized to administer oaths in connection with any matter relating all proceedings in the implementation of the Katarungang Pambarangay. The city or municipal mayor, as the case may be, shall see to the efficient and effective implementation and administration of the Katarungang Pambarangay. The Secretary of Justice shall promulgate the rules and regulations necessary to implement this chapter. As to the budget of the Katarungan Pambarangay, such amount as may be necessary for the effective implementation of the Katarungan Pambarangay shall be provided for in the annual budget of the city or the municipality concerned. Thank you so much for watching. For questions, you may post it in our FB page.